The next authority is Quadrilla, which is tab 20 of the authorities bundle. And that was an appeal against a committal for a breach of an injunction granted on an interim basis against anti-fracking protesters. And the form of the defendants there used is similar to INEOS, i.e. defined by a future conduct. Another point to note about Quadrilla is that it wasn't a pure queer timid case, because when the interim injunction was granted in June 2018, there had been previous activity at that site. My Lord, the main judgment is by Lord Justice Leggett, and one sees from paragraph 2.
So you're making the point it's not quite timid, or not just quite.
Well, it's not pure queer timid.
And you're saying that, all right, and you made the other point that the defendants are defined by reference to future action.
My Lord, yes, as in INEOS. One sees from paragraph.
See how this is on the as they describe.
My Lord,
Persons
yes,
are entering or remaining without the consent of the claimants on land. So that's trespass.
That's trespass. That's right.
That's on, and that is that's the claimant's land, is it?
That's correct.
Either entering or remaining without the consent.
Yes.
Persons unknown interfering with the passage by the claimants and their agent services with or without vehicle from and over and across the public highway. Persons unknown interfering with the passage.
So that's obstruction of the highway and preventing in and out.
That's right.
So that's right. And then persons unknown committed the act specified at paragraph 7 of the order.
Yes.
You'll show us that. Now, was there any? I have read this very briefly, very quickly, and of course, my Lord Justice David Raystead was in this. But was there any challenge to 1 and 2?
No, because the
descriptions in 1 and 2.
No, because the appeal here was against the committal based upon paragraph 4, which we have at paragraph 14 of the judgment.
That's the passage point, the description of the defendant, and then the injunction with the person free within that description from carrying out the following acts on any part of the access route.
So that paragraph 4 is restraining private nuisance.
Is it private nuisance? Why is it private nuisance?
Well, it's
Striking the highway.
blocking any part of the building at the site entrance, and anyone.
4.1 is private nuisance. I suspect that 4.2
must be.
I think it's both, my Lord. Yeah, absolutely.
Right.
And that one was concerned with both public and private nuisance appears from paragraph 13, just before that, where the two elements of public and private in relation to access to the highway and on the highway are summarised from Clark and Lindsay. So, owner of land has a right of access to the highway, and then, insofar as there is obstruction of the highway, you can maintain a claim if you suffer delay or other damage over and above that suffered by members of the public.
Correct.
And the issue in the appeal was that the relevant terms of the injunction were insufficiently clear and certain to be enforceable by committal, because they made the question of whether conduct was prohibitive depend on intention, and we get that from paragraph 2 of Lord Justice Leggett's judgment.
So just going back to 14, if I may again. So 41 is with a view to slowing traffic,
Yes.
with the object of slowing them down.
Yes.
So it's 4.1 and 4.2 with a view and with the object.
That's correct.
That's the bit of it.
Yes, and then in each case, with the intention of causing
intention
injury.
of. Right. Right, and so where are you taking us to next?
And then, I think then to paragraph 50. Where Lord Justice Leggett is considering the Ineos case and having reproduced Lord Justice Longmore's tentative requirements, then refers in paragraph 50 to Hubbard and Burris that have been cited to that court. He says in paragraph 50, in the light of precedents which were not cited in the Ineos case, which have been drawn to our attention on the present appeal, I'd enter a caveat in relation to the fourth of these requirements. Well, it's undoubtedly desirable that the terms of the injunction should correspond to the threatened tort and not be so wide they prohibit unlawful conduct. This cannot be regarded as an absolute rule. And then refers to Hubbard and Burris.
Right, so that's a statement, isn't it? I mean, that's... Is that part of the ratio?
It's not, no.
That's not.
And we must see the whole paragraph.
Yes. And it goes on to say...
In both those cases, the injunction was granted against a
named person, that's correct.
Then the next sentence is quite significant.
Absolutely, that's right. And then it depends whether it applies where it's persons unknown. And equally, the point I'd add is that they were both interim injunctive cases.
So what do you seek to get out of this case?
Well, it's simply, I mean, I think my learned friend, Miss Wilkinson, says that the court has a choice. That this doesn't necessarily follow from Ineos. It seems to me that Lord Justice Longmore's principles in Ineos were in themselves only tentative. And all that the court in Quadrella was doing is saying, well, we've been shown two additional authorities, which mean that there may be a requirement to revise the fourth requirement. But, you know, it's not necessary for us to do so in this case, and we don't. And moreover, we note that those were cases against named defendants, and the point arises being determined here. But I'm taking my lord to it because it's more recent. But I don't say that
you're saying nothing more basically than it's undecided.
Yeah, I can't say it goes any further than that. And the final.
But I think that certainly Burris and Adzani and Hubbard and Pitt. Well, but certainly Burris and Adzani. And yes, and Hubbard and Pitt, I think, certainly do show that you can have an interlocutory injunction
yes.
against a named defendant, which may turn upon intention. Is that right? One, they may turn upon intention, and also may prohibit lawful conduct.
Yes, it's the lawful conduct.
Maybe it's the lawful conduct. So that they definitely do decide that,
yes.
Do they not? That is part of their ratio.
Yes.
You can have that. So interlocutory injunction against a named defendant can restrain lawful conduct where that is necessary.
That's correct, yes.
Where that is necessary to protect the claimant.
But what the case doesn't decide is anything more than that, and it flags that there may be a difference where it's a named defendant and an unnamed defendant.
Yes.
Our case simply on that is that there is no reason in principle why the court's powers should be wider where it's a named defendant as opposed to a defendant defined by their future acts.
I'm interested, however, also in the definition of the defendants. There was no challenge to the definition of the defendants. What is paragraph 7? Can we find where's paragraph 7 of the order? What does it say?
Paragraph 16,
Yes, it's paragraph. That's unlawful means conspiracy.
Prohibited person committing any of the following offences or unlawful acts: obstructing free passage, blocking the slow walking plan, Oh, I see. So
So is this right? The three classes of persons unknown correspond with the three causes of action. The first group is the trespass, the second group is the obstruction of the highway and the interference with access in and out, and the third is the unlawful conspiracy, which largely overlaps with the obstruction of the highway.
Insofar as from the report, yes, that's my understanding.
So if we look at the very front page of the judgment and look at the three types of persons unknown, that's how they appear to me to correspond to the three causes of action.
My lord, is set out in the order, yes.
So the third category of people, the only addition it was to 1 and 2 was that they did the same acts, but with the agreement or understanding of any other person. That's the only addition. The same acts, but with the agreement or understanding of any other person, and therefore
I think that's,
unlawful means conspiracy.
yes.
And also it was not restricted to a particular bit of road. I think paragraph 4 is restricted to the PNR access route. I think that paragraph 7 is not so restricted,
Yes, I see.
I think.
Right, anyway, yes, you got that.
And I think all that I wanted further to take from Quadrilla is paragraph.
And what was the end resulting? What happened on this appeal?
The appeal against the committal of the grounds of the injunction of relief was uncertain, was rejected.
Was
Rejected, yes.
So it wasn't too uncertain.
That's correct.
Right, so this is therefore his authority that you can have an injunction which specifies with a view with the object and intention.
Yes.
So intention and purpose is permissible,
Yes.
possibly. A non-committal from Ms. Wilkinson. What is your submission on that point?
My lord, it's not necessary for our case, but the Court of Appeal here did uphold the committals based upon those paragraphs. Well, the only other point I draw from the judgment is in paragraph 79, where Lord Justice Leggett comments on paragraph 4 of the injunction. That's the injunction in relation to the PNR access route. And he adds, it's not been argued, I see no reason to think, that on the facts of this case, paragraph 4 of the injunction, as it stood when the breach occurred, was too widely drawn. And he notes that in Idios, a similar injunction was criticised.
Which is paragraph 4 of the injunction?
Paragraph
That's what we were looking at before,
Yes, my lord, that's right.
for paragraph 14.
Yes. But here he notes that although a similar word or term was criticised in Ineos, in that case there was no previous history of interference with the claimant's rights. And therefore, in that case it's pure queer timid. It refers to what Lord Justice Longmore said in Ineos about in retrospect, whereas in this case there was a well-documented history of obstruction, and therefore the injunction was warranted. The only point I seek to draw from that is that where the court is considering pure queer timid relief, and it's based solely upon risks for the future without anything actually occurring at the site, it must indeed be extremely cautious, both in terms of whether to grant relief and its terms. But where there is actually evidence of wrongdoing, as in Quadrella and indeed in the instant case, the court can be emboldened to grant somewhat wider relief because it already has evidence of wrongdoing to demonstrate it is necessary as things will turn out.
I think Lord Justice Leggett really deals with this as a matter of principle in paragraph 74.
Yes.
Yes, so it does seem the authority for that, doesn't it?
Yes.
This authority that intention is okay.
If there's an issue, it's with the claimant and then having to prove the intention on
Say
committal.
intention. Right. Are there any other cases of zoning?
My Lord, not of this court, but by exclusion zones.
Yeah.
My Lord, no, there is an old case of Lyburd and
Animal rights protesters. I mean, there've been lots and lots of these.
not of the Court of Appeal, no.
Nobody
I think there are quite a few orders made at the first instance, but almost of necessity they're almost always made when there isn't a great deal of opposition to them. So well, there is an old decision of this court in 1981 called Lyburd and Cork, which is Lord Justice Waller, Evelyn and Sir John Wills, where it was two neighbours, and one was racially harassing the other one, and ultimately the court ordered that the defendant was not to live at his home, and it said because the only way to protect the plaintiff's rights is to exclude him, full stop.
But does seem that we've got, right, which is our next case?
Well, the final one under this ground is one is Cartier International, but I should preface it by saying it is an extremely different case concerning website blocking injunctions. So very, very different. We refer to it in our skeleton argument, and I refer to it for 2 points. Simply that in that case, the Court of Appeal stated the power under Section 37 to grant injunctive relief is not limited to where a defendant has invaded or threatened to invade the rights of the claimant or has otherwise acted unconscionably. And the courts can grant injunctive relief under Section 37 where it's necessary and appropriate to do so to avoid injustice. But it's very different. but I take you to it. It's tab 15. And this was a case where Cartier and others sought website blocking injunctions against internet service providers, requiring them to block websites that were advertising counterfeit goods which harmed their interests. And such orders were granted at first instance and upheld by the Court of Appeal. The Court of Appeal also ordered that the costs of complying with those injunctions were to be borne by the defendant ISPs. There was an appeal from that part of the judgment to the Supreme Court, which reversed that order and held the costs were to be borne by the claimants. But what the Court of Appeal said about the scope of Section 37 was not commented on by the Supreme Court. And one sees from the head note that the claimants sought injunctions against the defendants to impede or restrict access by their subscribers to the offending sites. And they refer to Article 3 of the Enforcement Directive, which required member states to provide remedies necessary to ensure the enforcement of intellectual property rights which were effective, proportionate and dissuasive, and which didn't create a barrier to legitimate trade, then Article 11 required member states to ensure that right holders were in a position to apply for an injunction against intermediaries whose services were used by a third party to infringe an intellectual property right. Now, here, Article 11 had not been brought into domestic effect, and therefore the claimants sought their relief relying upon Section 37 of the 1981 Act. And one sees they did so two-thirds of the way down just by G, on the grounds the court had jurisdiction to grant the injunction sought, whether on a purely domestic interpretation of Section 37 or interpreted it consistently with the UK's obligations under Article 11 of the directive. And the Court of Appeal held that on a domestic interpretation, Section 37 did empower the courts to grant that relief. The leading judgment is by Lord Justice Kitchen. Now take it to paragraph 33, please. Where one sees the issue put before the court as to jurisdiction. The ISP is saying there was no jurisdiction. And then the response, page 17, internal, just below A, they developed their argument in two ways. They could first, the court had the necessary jurisdiction upon what they called a purely domestic interpretation of Section 37(1). Paragraph 40, Lord Justice Kitchen begins with Section 37, and he then refers to decisions in the Susquehanna, paragraph 42, and to the South Carolina insurance case in paragraph 43. And then he records the submission for the defendant ISPs in paragraph 45. Founding itself upon the speeches in these cases, Ms. May contends that ISPs have not invaded or threatened to invade any legal or equitable right vested in Richemont, nor have they behaved or threatened to behave in an unconscionable manner. It follows, she says, that the judge had no basis upon which to make the website blocking orders in issue in this case. And Lord Justice Kitchen says, it's clear, however, the matters have moved on since 1986, and the courts have shown themselves ready to adapt to new circumstances by developing their practice in relation to granting injunctions where it is necessary and appropriate to do so to avoid injustice, just as Lord Gough anticipated. And we've sidelined the quote from Lord Nichols. And then,
it's really just that general proposition that you're citing this.
my lord,
Is it just for that general proposition the courts develop as remedies according to new circumstances?
my lord, and what is then said in paragraphs 53 and 54. Because there, Lord Kitchen says, also relevant is the approach adopted by the House of Lords on further appeal in the same case, as a duty imposed by those who through no fault of their own get mixed up with the tortious acts of others. Which is, again, and then at 54, I recognise that ISP are not guilty of any wrongdoing. They have not infringed Richemont's trademarks, nor have they engaged in common design with operators. Also, clearly they don't owe a common law duty of care. But that's not the end of the analysis. And then just above D, in my judgment, this would impose a straitjacket on the court and its ability to exercise its equitable powers, which it is not warranted by principle. And it's the general point about developing to circumstance.
That's the
Yes. Well, we rely upon that because we accept that the terms of the injunction restraining no more than 12 to protest in the outer exclusion zone does impact on people who have done absolutely nothing wrong and would be acting entirely properly. But where they have combined, where there is a risk combination together, as in this case, in order to do justice and to protect the claimants, the appellant's rights, the court does have power under Section 37. My Lord, I think that's probably all I want to say on ground two.
I'll just pause for a moment.
My Lord, moving on to ground 3, and this, we do say that the judge erred in law in his approach to the principles applicable on summary judgment. And in particular, it would appear in our submission that he focused still on the formulation of the defendants in the claim form as issued, not on the substitute alternative formulation, and appears to have held that it was incumbent on the claimants to name the 37 individual, or rather to make parties the 37 individuals who it could name, who had been saved with the injunction, proceed against them only and seek to prove what it could against them, but left out of account all the additional class, that is, those who the fear was would commit unlawful acts in the future. And there are a series of paragraphs in his judgment where he sets out his concerns. I don't take my lords to them. It's paragraphs 146 following. But the nub of his conclusions of paragraph 165. Where he says, it's page 126 in fact, of the court bundle. So paragraph 165, where the judge says, in relation to the first defendants and those whom the second defendant acts in resident capacity, it is impossible to answer the question whether they have a real prospect of defending the claim, because it is impossible to identify who they are, what they are alleged to have done or threatened to do, and what defence they might advance. Now, whilst we accept that that is a fair criticism of the way in which the claim had been issued as against the defendants, that wasn't a fair criticism given the proposed amendment, which sought to define the defendants only by reference to future acts. And that whilst the judge held that the appellants should have joined individuals as named parties, it didn't follow that it was only entitled to summary judgment or to maintain a claim against those named parties, because it still had the entire other category of yet to be identified persons against whom relief was sought based upon what had happened in late 2017 and the risks of that repetition in the future.
But he found that there were a variety of reasons why there was no entitlement to summary judgment, didn't he?
He did, my lord.
I mean, that's the last paragraph.
Well, my lord, a lot of the points are interlocked.
I mean, there's the point about homogeneous unit and all the rest of it.
My lord, that's right, but it all stems from the judge focusing on the original formulation of persons unknown, and not on the more restricted formulation.
Well, that may be a factor, but another factor is the failure to join individual defendants.
Yes.
And his concerns about that a justification for an order against persons unknown could only be made out if the protesters could properly be regarded as a homogeneous unit, which is 155.
Yes.
So there are a number of, I think the only point I'm making is that there are a number of strands.
There are, yes.
And so I'm not, at the moment, entirely comfortable with taking just this one point out, that's to say the formulation of the defendant's point, as if somehow that's a complete answer to the judge's refusal of summary judgment.
Yeah, I'm not suggesting that for a moment. I mean, I can take my laws to the various paragraphs which he makes similar or related points.
Yeah.
So
there's clearly a point. I mean, there's clearly a point he had in mind, along with quite a few others. Put it that way.
Well, that's right. So paragraph 146 says there then is the issue of who are the defendants caught by the first defendant persons unknown. It misses the issue of service. Nothing in the operative definition of protesters required or assumed any wrongdoing on his or her part. If the court granted judgment against the whole class of persons unknown, it would capture in the net indiscriminately the guilty and the innocent, with no way of distinguishing between them. Now, again, that was a fair criticism of the original formulation, but not with respect to the alternative formulation.
I need to see that. Let's have a look at that again. Where is that?
The substitute draft order is in the core bundle at page 191.
And it's set out in the next paragraph of the judgment. You took us to what you were reading from 146, and it's in 147.
My lord, yes, the definition of protester, the defendants is, and the actual terms of what was sought against them is set out later, that's right.
And that's
involved in are involved in any of the acts prohibited by the terms of this order. But we've looked at that,
yes,
and we've seen that some of them
involve
lawful activities. I mean,
yes.
so we keep on coming back to the same point.
Yeah, but there are 2 points here. Firstly, our point, ground 2, that the judge had power to make orders against individuals where the acts were potentially lawful. That's the Burris point. But the second point is that even if the judge was right, and some of these provisions prohibited lawful conduct, his proper course was simply to strike them through from the definitions or from the orders and leave only those elements which he was satisfied were tortious.
Poor judge, I mean, you ought to have done this. Did you tell him you should do that? Was that a submission that was made, that was an option open to him?
I don't think that was.
I mean, it's a bit unfair to say he should have done it, but nobody suggested it. I mean, it was presented to him as a take all or leave all.
Well, it was presented to him to seek to meet the concerns expressed at the hearing. And I think that
But it doesn't, that's the problem. Because it necessarily includes people engaged only in lawful acts, who are the innocent.
Well, as I said,
He's saying as a matter of principle, we shouldn't group the innocent with the guilty.
but as I say, if that was his concern, then it could have been addressed by.
No, it wasn't put. Anyway, let's never mind what he might have done.
Yeah.
I mean, I don't see why it's not a legitimate point in respect of your revised definition of D1.
Well, as I said, I've accepted that some of the provisions are ones which offend against that.
Exactly.
And then paragraph 150, there is the, well, in fact, 149, there's the point, having rejected the alternative formulation, these are the unavoidable consequences of utilising speech of suing persons unknown but making any attempt to discriminate against those against whom there's evidence of wrongdoing, those there is not.
So where are you reading from now?
149, my lord. Now here, even accepting my lord Justice Davis's point about still being offending provisions, there had been an attempt by the claimants to discriminate between those against whom there's evidence of wrongdoing and not. Simply that the judge even then didn't consider that what was in the substitute order caught only wrongful conduct.
But I mean, it's quite difficult to grasp in a way, because if the injunction is extending to people who have not yet demonstrated at all outside the premises,
Yes.
which it is intended to do, you never will have evidence against them. Well, very unlikely to have evidence against them. You might, I suppose. But this is a contra mundum injunction. So necessarily, there is absolutely no evidence against the vast majority of people to whom it's addressed.
There is evidence from.
There is evidence that some people might have engaged in these activities, and unless restrained might
Well, that's
do
right.
so again, as might others.
Yes.
But I mean, I think what you're saying is, well, you shouldn't need to produce any evidence
No, not saying.
about, except, well, have to produce evidence that there's a real threat,
Yes.
but not as against any particular defendant.
Well, when the claim was commenced, there was no defendant that could be identified, and therefore it's
Correct.
entirely appropriate
I
to do
understand.
on that basis.
That's-
Once the claim is issued, we accept that the injunction was served on a number of individuals. In the case of 37 of them, they could be named, although some were.
Absolutely. I understand that.
Yeah. But even amongst those 37, there is no clear evidence about how many of those had actually undertaken acts in breach of the terms of the injunction, as opposed to having been protesters at the site and served with the injunction. And even those who had been served, it's more that they may have breached one of the terms of assaulting or threatening, but not undertaken the kind of conduct prohibited by the orders because they were in place. And so when the judge is looking at the category of defendant and saying, well, if you're describing them by virtue of acts, including restricting protests outside the shop, you have to look back at what happened in November 17. That is what happened on the ground when there was no order. What you are seeking to catch is...
It's just like my Lord's example of the exclusion zone around the abortion clinic. I mean, what you're basically saying is there is a real risk of demonstrations and so on unlawfully impeding our ability to carry on our business, and therefore the court should create an exclusion zone. That's actually what you're after.
Well, no,
it's not really an injunction against individual people about whom you can have any evidence.
But it's in a sense, my Lord, whenever queer timid relief is sought on a basis such as this, you're often not going to have any evidence against individuals.
Yes, you are, almost all. Oh, do you mean in this type of case?
Yeah.
No, I understand that in terms of interim injunctions, yes.
But and then when one goes towards final relief, whether that's summary judgment or otherwise, one would expect that if injunctions are in place, they will have been complied with, because that is the purpose of the court granting injunctive relief.
I understand. But I mean, perhaps your point is that the judge is setting a completely impossible target.
Well, he is.
Because you can't gain evidence against anyone except those who have actually protested already, or whom you can show are engaged in acts preparatory to demonstrating. And that necessarily is going to be a relatively small number of people.
It is, that's right.
So basically you're saying you don't, in a case like this, you don't need to show evidence against any particular member of the class covered by the injunction. Aren't you really saying, you're putting it in a very general way?
No,
there is a risk of demonstration.
Well, I'm saying that...
Because we know there are people out there who have strongly held views and will engage in direct action to
No, we are relying upon the evidence of what happened in November and December 2017.
I do understand that.
And that demonstrates...
But as being emblematic of what may occur in the future.
Well...
I mean, if you were only concerned with what had happened in November and December, then you would take steps to identify the individuals concerned, join them as defendants and get injunctions against them.
But joining, say, 20 individuals to a claim, where your concern is about the 400, and there
you might be able to get the 400, I don't know.
My Lord,
I mean,
that is not the case.
An injunction then, I mean, somebody said you have photographs and so on. I mean, whether you would at least be able to say have an injunction against all those persons who attended on the whatever date it is in November and took part in the demonstration. I'm not saying that is a legitimate injunction to grant, but it would define a class by reference to what people had actually done.
But we are seeking to define a class
by reference to what
future
people
action
might do in the future.
But relying upon what people have done.
But not necessarily those people.
Well, no, but that's
People in general.
those protesting at this location against the appellants. That's the nature of the protest. Well, Lord, I think we've sought to summarise our concerns about the judge's approach in the list of issues, which were submitted to the court and which the advocate has very helpfully given answers to. And we have also sought to address those issues ourselves in our supplemental note. I don't propose to go through that note, and my Lord will see that we seek to answer the points there, and we do seek to set out, insofar as the court is willing to give guidance as to how claims of this sort are to be managed, what those principles should be, in particular in relation to the Gamble case and the service of injunctions and the like. My Lord, unless my Lord wishes me to deal with any of the particular points in particular, I'm happy to rest on our written submissions on that.
Is your written submissions on what?
On the issues raised in section 5 of the list of issues, which the advocate has responded to, and which summarised our concerns about the judge's approach to claims of this nature and summary judgment. And these include giving our assessment of the Gamble case and what that requires.
Can we just go through? We'll just go through the order.
Well, yes, I've had copied the substitute draft, showing the differences from the order grants on the 15th of December. Would my Lord like that?
That'd be very helpful.
There we are.
Has there been any case of a final injunction against persons unknown, apart from, I think, the case of the Bromley case? That was a final injunction, wasn't it?
Yes, but we didn't. We rejected the injunction.
Right. Has there been any case? I don't think you've cited anything to us yet. A final injunction against persons unknown.
There's Bastards, isn't there? Isn't that the only case?
Yes.
Actually,
First instance, I think there are cases, but certainly.
Bastards you have put in the bundle.
Yes, Vastin certainly, and that's a trespass case. But certainly, I don't think
it's
there
well
are.
established there.
I don't think there are any trespass cases, any non-trespass cases.
I mean, it's
But that's quite easy to identify what the wrongdoing is.
Yes, it is. It is.
That's very easy.
It is.
So, I just want to try to understand the next back. I think you accepted. Let's go through assaulting, molesting, or threatening the protected persons. That's obviously unlawful.
Yes.
Behaving in a threatening and or intimidating and abusive and insulting manner. Well, that may be unlawful or not unlawful.
Well, again, we'd say it's unlawful. Again, that's a form of assault.
I mean, what? Be abusive to somebody isn't necessarily unlawful. Depends what the nature of the abuse is. But if you swear at somebody, that's not a criminal offence or a civil offence. So at the moment, it seems to me that may or may not be unlawful. Entering the store without consent and remaining in the store when asked to leave, that is unlawful.
Yes.
Blocking or otherwise obstructing the entrance of the store, that seems to me to be unlawful.
Yep.
Protester. Banging on the windows of the store is unlawful at the moment. Painting, spraying, or fixing outside the store, that's unlawful.
Yep.
Then you've got demonstrating in the store, that presumably is covered also by 5, presumably asked to leave. And then you've got these exclusion zones.
Yep.
Now, I want to try to delve down into what's happening with these exclusion zones. There are two different things. So you've got demonstrating within in an exclusion zone at all.
Yes.
And what is, just remind me, what is the distance there?
That's 2.5 metres width.
2.5 metres on either side of the entrance.
No, out from the entrance, and then
From the
extending all the way along the frontage on Regent Street, but only a very short distance along Little Argyle Street. Well, the plans are 198. Terribly sorry.
There's a plan in the exclusion zone.
So there is part of the inner exclusion zone, which is the entirety of the pavement.
On Little Argyle Street, yes. But then there's
So heading east into Soho from Regent Street. there is a part of that side of the road which is wholly covered by the inner exclusions.
My lord, that's right, it is.
Now, what unlawful activity underlies that injunction?
My lord, it's two elements. It's seeking to enforce the prohibition on obstruction of the entrance to the store, and also to enable those who come in and out of the store to have a safe space in which to go either down Regent Street or Little Argyle Street. And it was also sought to remove, insofar as one can remove, the risk of banging on the windows, which I accept is also prohibited.
Now, why should one person standing on...
I'm told that's where people queue to get into the store as well. So there may be queues of people waiting to get in. Sorry, my lord, interrupt.
Is that in the evidence?
We will find the reference. If it's not, I'll withdraw the point.
Somebody see where that is in the
Yes.
And is that for both of them? So that those explanations are for. So there are three. As I understand, there are three explanations for that. So obstructing the store to enable people to go in and out. A safe space for people going inside and outside, legitimately. And thirdly, interference with the queue of customers.
And banging on the window. Yeah. The four reasons.
Well, that's separately covered.
That's covered anyway.
It is, yes, it is. But similarly, as in Burris, there were injunctions not to do acts. The zone was further to reinforce that.
So that covers even one person with this. So the only question there is, I mean, that's the reason. That's the reason that those two are there.
Yes.
It's basically private and public nuisance.
My lord, that's right.
What about using a loud hailer within the inner zone and the outer zone? What's the unlawful activity there?
My lord, the unlawful is seeking to restrain private nuisance.
Yes, but it depends how loud the loud hailer is.
My lord, I
I mean, there's legitimate protest you
Yes.
can have.
Yes. And that's why, at least how the order provides, is that there is to be, or there can be, a loud hailer use anywhere in the vicinity of the stall, not within the exclusion zone, either exclusion zone, between 2 and 8 p.m, 15 minutes on, 15 minutes off.
That's other than the human voice. 16 is dealing with amplification for anything other than the human voice.
That's right.
I'm dealing with 14 at the moment. Just trying to understand this.
Yes.
That seems to me at the moment to cover perfectly lawful activity.
Yes.
Right. Then you've got 15, using a loud hailer anywhere else in the vicinity of the store, outside the hours of 8 p.m. and 2 p.m. Well, that's the same point.
What does that mean, sorry, outside of the hours of 8 p.m. and 2 p.m? So just, what?
I think that you can't use it from 8 p.m. until in the evening until 2 p.m. the next day. The time at which you can use a loud hailer is 2 p.m. to 8 p.m. Afternoon store hours.
Those two are lawful activity. Then you've got using a loud hailer anywhere else in the vicinity of the store between the hours of 2 p.m. and 8 p.m. Anything on the human voice. I mean, all those seem to me to cover all sorts of things. But what you haven't, you're not using here. Then perhaps you don't think it exists anymore. outside the harassment, the Protection from Harassment Act, watching and besetting. I'm not saying you should, but I'm just interested to know you're not doing that.
Well, I mean, that remains there, but I mean, we say we don't need to go any further than establish private nuisance, in that, you know, if acts are committed on the highway with, I accept it has to be loud hailers or for a long period of time, that gives rise to private nuisance. But I accept that the use of a loud hailer in and of itself is not unlawful. Paragraphs 14 to 16 were sort of crafted together to seek to restrain conduct which was considered to be unlawful, i.e. crossing the boundary of private nuisance, but permitting use of a loud hailer for the human voice for some 6 hours per day every day, 15 minutes on, 15 minutes off, in the light of the use of loud hailers before that, and that was their use on siren mode, upsetting members of staff and customers.
Well, that doesn't matter because you're allowed to protest upsetting people. That's one of the problems.
Absolutely.
Well, is there anything you can think of that could save 14 to 16 at the moment? I mean, at the moment it seems to me they're too wide.
I can see that in terms of breadth, I can see my Lord's concerns. The issue is, and what I think the appellants ought to do below, was to try and craft something which met the merits of the circumstances. But it was always incumbent on the judge to narrow that if he felt that it was too extreme.
I think you're putting quite a burden on the judge. And the judge would say they're too wide. What you're suggesting is an order. It's not for the judge to craft an order.
Can I turn my back, please? No.
Just read again how you put this in your alternative form. Let's assume that all those were out. 14, 15, 16 are out. Let's assume 2 is out. And you've left with the rest.
Yes.
Sorry. 2 is out. And 14, 15 and 16 are out.
Yes.
Relate it to your definition of your defendants. Persons who are present and in the vicinity of and are protesting against manufacturing, supply, and are involved in any of the acts prohibited by the terms of this order. So you're happy because that catches everything else, but more to the point, the exclusion zone.
Yes.
Just help me with 13. You've got 12 people and somebody comes along and joins in. Is that then, are all then 13 people in breach of the order?
No, my Lord. I think the intention here, it is the 13th person who joins, who is in breach.
They may not be counting.
Well, that will be a difficulty for the claimant to enforce. But certainly, it was the difficulty. I think it was appreciated that the previous form of order didn't have any sort of distinction about who would be potentially in breach. And this, I think, was an attempt to try and make clear that if 12 people are there, it's perfectly fine. It's the 13th, 14th people who there is the problem with.
Can I just look at the brackets? Right. If I could understand demonstrating the store within the outside at any time when there are already 12 elderly, you say that's justified by public and private nuisance.
Yes.
Obstruction of the highway, obstruction of the entrance and exit to your property. Then you say for the avoidance of doubt, this does not prohibit up to 12 people at any one time demonstrating and handing out leaflets within the outer exclusion zone, provide that no obstruction occurs other than which is implicit in handing out. Don't understand that. They're allowed to. Why can't they why do you need that? Why can't they demonstrate in any way they think appropriate?
I don't think you need that, my Lord. You don't need that.
mean, they're allowed to demonstrate.
Yes.
The only objection could possibly be to obstruction.
Yes. Which
Or
is
public or
already
private
prevented by-
nuisance.
Yes. You don't need that.
Right. So that's what we're looking at. I mean, if, at the moment it seems to be pared right back. That's what you say, on even taking into account the judge's comments on lawful activity.
Yeah.
Paring that right back, you say that is at least what the court should grant under that description of the defendants.
Oh, that's right.
I'm just trying to be pragmatic here. Right. Anything else you want to ask? Anything else you'd like to ask? Anything else you want to ask at this point? No, well, thank you very much indeed, Mr. Beth. Yes, Miss Wilkinson. Miss Wilkinson, we're extremely grateful, it goes without saying, for you being here to give us assistance. I mean, at the end of the day, that is what we're looking at. When you pare everything away, the question is, does the court have power to make such an order? Of course, I'm skipping ahead because are you going to address us on service or not? Are you? Or are you?
My lord, I wasn't instructed to address you on service, but I have one point on service that...
Well, I mean, anything you can give your help on, very gratefully received, because there is no opposition here as such.
I mean, you'll have seen, my lord, that in responding to the list of issues, what I have said is necessarily at a fairly high level of principle and of abstraction. And it seems to me that the issues I've addressed so far really are relevant if you intend to give wider guidance about the issue of final quia timit injunctions against persons unknown. I have not addressed you on the specifics of applying that to this case, but I'm happy to respond to the points that Mr. Bowes has made so far.
Yes, that was very helpful.
If we could pedal right back then with a preliminary point on joinder,
Yes.
and I think this is the only point on which I can assist you outside the list of issues. The question was raised this morning as to the status of PETA at the point of joinder, because it's accepted that His Honour Judge Maloney joined PETA
Yes.
on the 15th of December 2017, and that order is at supplementary bundle tab 15. But the question then arose, having been joined, were they in fact to be taken as having been served, and therefore to have, whilst they'd accepted jurisdiction in the sense of joinder, had they accepted jurisdiction by merit of service? And that point was left unanswered. The answer is not entirely clear, either from the CPR or from the authorities. The CPR answer is in part 19, practice direction A, which begins at page 680 in the White Book. So practice direction 19A is dealing with the power under rule 19.2 to add or substitute a party, and under additional substitution of defendant in 19 APD.3 there are various procedural requirements that the court may direct. In 3.2, the court may direct 1, the claimant to file with the court within 14 days or as ordered an amended claim form and particulars of claim for the court file. 2, a copy of the order to be served on all parties to the proceedings in any other person affected. 3, the amended claim form and particulars of claim, forms for admitting, defending, acknowledging the response back, in other words. And 4, unless the court orders otherwise, the amended claim form and particulars of claim to be served on any other defendant. So this is the service of corrected documents to all parties and all interested parties. And then at 3.3, the critical provision, bearing in mind that though this is a practice direction, not a rule, a new defendant does not become a party to the proceedings until the amended claim form has been served on him. And one would imagine that the purpose of that, as a matter of procedure, is that there may be consequential amendments in the amended documents, which any joined or substituted party would wish to take notice of and to respond to. I've managed to find 2 authorities on the point. The first is a pre-CPR decision of the House of Lords called Ketterman and Hansel Properties. Ketterman. I'll hand them up, my lord. But then...
It's many years since Ketterman's been cited in a court that I've sitting in. It was once a case I knew terribly well. I can't now remember anything about it at all.
That disappoints me, my lord, because I've only read it in a very cursory fashion. We may have to relearn it together.
You've got copies to hand.
I have copies to hand up. And as I hand them up, I'll hand up a 2015 judgment which casts some doubt on the general principle in 3.3. That's 1 copy, 2 and 3. Thank you. Limitation, exactly, my lord. In speed reading it in the short adjournment, I picked up that much too.
I'll quit now. I remembered it was to do with limitation.
So as I understand it, Ketterman was a question of the exact date on which a party had been joined to the proceedings, because if it was the right side of one date, the claim could be validly brought and there was no issue of limitation. If it was the other side, then it was out of time in limitation terms. If we just look at the head note, my lords, I think the facts are really neither here nor there in terms of the underlying cause of action. But on page 190 in the head note, at B, we find
relation back, that's it, relation back. Sorry.
The judge allowed an amended defence, and though it alternatively pleaded the defence of limitation as from the date of occurrence of the defects, he ruled that the joinder of the local authority and architects as defendants took effect from 30th of July 1982, less than 6 years after the damage occurred. The judge gave judgment for all the plaintiffs against the builders and for the first, second and fifth plaintiffs against the architects, but he dismissed the claims against the local authority and held that the claims of the third and fourth plaintiffs against the architects were statute barred. On appeal, the Court of Appeal dismissed their appeal and allowed the cross appeals against the architects, holding that the action against the local authority and architects had to be taken to have commenced on the 27th of May 1980, the date of issue of the original writ, so that none of the plaintiffs' claims were statute barred. And the bit we're interested in is the decision at 190 between D and E, that a person added as a defendant did not become a party until the writ had been served on him, and that the architects, though never served with an amended writ, had by serving a defence on the 6th of October 1982 waived the necessity of service, and were accordingly joined as defendants from that date. That further, in computing the period of limitation, the date of joinder was not to be related back to the date when the original writ was issued, and accordingly time only ceased to run from the deemed date of joinder. From which I take you can, on the authority of Ketterman, even where there has not been service of amended documents after a party has been joined, that requirement can be waived if you've nonetheless served a defence or an acknowledgement of service.
But there's no defence here.
but there's no defence here or acknowledgement of service. And if I just give you one reference for later on in the judgment where
So PETA must have made some application. Looking at 15. It says, on the application dated the 12th of December 2017 by PETA Foundation. What was that?
that was to be joined.
Yeah, because it says but paragraph 6 of the order is not later than 2 p.m. on Thursday the 14th of December 2017. The complaint shall file and service evidence in reply to PETA Foundation's applications, if so advised. No, I see. The APM PETA Foundation will file and serve a draft order setting out the variations it seeks to the interim injunction, should it not be discharged. Is that what that's all referring to?
Yes, my lord.
I mean, if somebody makes if somebody asks to be joined and then makes applications of one sort or another, I mean, it doesn't make much sense to say they're not a party.
And that was the point that His Honour Judge Pearl took in the second case I've handed up, my lord, which is a 2015 case.
But Kettleman, I haven't looked at this one, but Kettleman is all to do with fixing a date as to when they became a party, because that was relevant to limitation. So you needed to identify a date from which it could be said that they were a party.
That's right, and that's at 199A in the judgment of Lord Keith.
Because the whole point about Kettleman was that the House of Lords said it dated from then, so you didn't get relation back. So it meant that if you were adding other defendants, you had to be careful because of limitation, because otherwise you might find your limitation period expired before you even knew you had a claim to pass on.
Exactly so, my lord.
Yeah.
What is the point we get out of Judge Pearl's judgment?
So Judge Pearl was referred to Kettleman, and we can see that at paragraph 61 on the final page of the judgment. And this comments directly on the practice direction, paragraph 3.3. And in this case, no directions had been given requiring service of the claim form. So His Honour Judge Pearl found it difficult to see how 3.3 could have any effect.
Well,
And
I can't really
takes your
see.
point.
Yeah, but I can't really see how PETA could turn round the day after the order and say, I'm not a party. And he applied to become a party. He must have applied, wanted to make applications.
And it appears that
Possible.
the subsequent procedural orders work on the same basis, my lord, in that Master Eastman made an order on the 30th of November 2018 permitting, this is a supplementary bundle tab 17, Master Eastman gave the claimants permission to issue the summary judgment application in accordance with Rule 24.41. And 24.41 provides that a claimant may not apply for summary judgment until the defendant against whom the application is made has filed an acknowledgement of service or a defence, unless the court gives permission. So Master Eastman was implicitly acknowledging the fact that there was clearly no intention by PETA to serve an acknowledgement of service or a defence, but nonetheless he was prepared to treat them as properly joined.
Which paragraph are you reading from then, in the order?
Paragraph 1, my lord.
Claimants are permitted to issue the application in accordance with.
Yes,
Page 306.
exactly.
Right. So what is the point you're making there?
That Master Eastman proceeded on the same basis that your lordship has, in that it makes no sense to turn round and say PETA seeks to be joined but because the technical requirements of service haven't been complied with, and that an amended claim form hasn't been served on them with their own addition in it, that they should not be regarded.
But haven't they, in the meantime, we were shown some communication from PETA.
But that postdates this order.
But what I'm saying is that acknowledges it's a party, doesn't it?
They submit a witness statement saying that they're not going to oppose the application.
In the old-fashioned
Yes.
phrase, that might be taken as a step in the action.
I mean, that's surely
I mean,
one of the ways of evidence.
If we're talking about acknowledgement of jurisdiction, I'm about to say I thought that Mr. Bowes was right, that it couldn't be said that PETA had done anything other than accept the jurisdiction of the court.
We're just reminding, they don't have to show it to me, but just remind me where that witness statement was, perhaps.
Supplementary bundle tab 13, my lord, dated the 15th of
Well, I
January.
think of all the things we have to decide in this case,
It
that
is a
probably
relatively
isn't
minor
the
one.
most difficult one.
But that is the
Thank you.
technical position under the
Thank you.
CPR,
That is
for what it's
helpful
worth.
to know, and Lord Justice Coulson will bear that in mind in due course.
Happy to take everyone to Kettleman for a day
The
trip.
rule is very sound, but you can, of course, waive your rights.
Give away.
Of course.
Right, that deals.
So, my lords, back to the main event.
Yes, thank you.
Perhaps it would be most sensible to start at the beginning of the 5.0, 5.1, 5.2 issues that I identified in the submissions, and just go through them one by one and work out which are actually still relevant.
Whose submissions? Yours?
My submissions, my lord.
Because you've done your submissions by reference to the issues.
List of issues, my lord.
Because, and to the extent that that creates problems, I apologise, that was my order. I thought it was helpful for you to respond by reference to the issues, because there were some issues which I thought you didn't need to address.
Thank you, my lord, and it was a perfectly sound organising principle, if I may say so. I think I've done it.
I think at the end of the day, we need to remember where we want to end up this court is with a view about whether or not there was proper service, and whether or not which is part of this, more particularly, the defendants in the original, as originally formulated, was impermissible.
My lord, yes.
That's the first point. Then there's a second point, which is the reformulation permissible in the light of is that permissible? We can deal with whether or not there was a formal application to amend, but on the taking it for the benefit of the claimants here, assuming there's implicitly an application to amend,
Yes.
was the judge right to refuse to do so? That seems to me to be the next question.
Yes.
And then the final question, which may or may not arise according to whether or not what we decide on the first two, but the final question is, and was the form of the order with the defendants in the revised form an appropriate order to make by way of a final order? They seem to me to be at the moment the three stages we need to go through. So anything you can say that helps us on that journey would be very welcome.
Well, taking those three questions, if I go through the list of issues and only focus on the ones that I think go to those 3 points. Issue 5.0 is the grant of a quia timet injunction against persons unknown only available in the exercise of an emergency jurisdiction, which is both provisional and strictly conditional. I don't think that's at issue.
Hang on. I'm now your submission to the Advocate of the Court, page 226.
Paragraph 22. I'm afraid my copy hasn't got page numbers.
It's numbered in the bundle, though.
Is it, my lord? I'm sorry.
231.
I've extracted mine.
231.
231.
231.
Right, 231. So, is the grant of a quia timet injunction against persons unknown only available in the exercise of an emergency jurisdiction which is both provisional and strictly conditional? Right, that is relevant. Yes.
Well, that's a quotation taken from Lord Sumption in Cameron. my lord, and my answer to that was yes. The actual quotation in 5.0 is a précis of Lord Sumption in Cameron at paragraphs 11 and 14. We can turn Cameron up, my lord, if that would assist. I don't think it's really an issue, my lord, is it? That
Well, I think it is an issue, isn't it? Because if one gets to ask the question, is the reformulation of D1 appropriate for the purposes of the summary judgment application, which I think is where this comes out of, then surely this is at the heart of that. Because the summary judgment was for a permanent injunction.
so the question is really whether you can have a final quia temit injunction against persons unknown
Of this sort,
of this sort,
yes.
which is, I think, issue 5.7, 5.8,
Somewhere.
somewhere else. Okay, well, shall we start with that?
Yeah, I mean, if one was just looking at whether there had been service in this particular case, without regard to whether, if there had been service, it would have been open to the judge to make the order sought, then of course it's a far shorter and very much more contained
Yes.
point. But I mean, I think that your third, in particular the third issue, at the moment it seems to me opens up this rather more fundamental question.
And I think the way I dealt with it is probably in my supplementary note, if I can ask you to have that to hand as well, my lords. The final paragraph, in fact, paragraph 38. And this paragraph deals with it at the level of principle, and then I'll try and apply it to the terms that the claimants seek. So what I've said is that on the basis of quadrilla, there's a fourfold matrix of factors that the court needs to consider in designing INEOS compliant injunctions. And it's only by a combination of those four factors that you can arrive at a final quia temit injunction against persons unknown that will satisfy both INEOS and potentially section 12 of the Human Rights Act in the context of articles 10 and 11. So the first is the description of persons unknown, which may include their intention, so long as not used in any legal or technical sense, and that's the Lord Legate point from quadrilla. Then the next factor is the description of the tortious acts to be restrained. The next factor is the description of any preparatory or non-tortious acts that might by their effect be tortious, where that description does not concern technical or legal terms of art. And if I can unpack that a little bit, what I mean is by their effect is where, as in the case of harassment, one act may not by itself be harassment within the meaning of the Protection from Harassment Act, but repeated incidents of that non-tortious act, or repetitions with aggravating features, may amount to a course of conduct that satisfies the description of harassment within the Act. And my lords, therein lies the rub between the various cause of actions in play. Trespass at one end of the scale is just simply trespass. You're either there with consent or you're not.
Yeah.
And then at the opposite end of the scale, you've got harassment, which requires a course of conduct to be built up over time. It may be a short period of time, it may be long, and there may be particular features of an innocent act, as in Boris in Adesanya, which render it harassment. And so, at the trespass end of the scale, you will, if you're seeking to restrain trespass, you need only ever list tortious acts in the injunction that will be restrained. But at the harassment end of the scale, you may, in my submission, have to list what I've called preparatory acts or single acts of non-tortious behaviour, which cumulatively might amount to a course of conduct which is harassment.
Yeah, but again, I'm being slightly sort of pragmatic here. Do I understand from paragraph 38 to accept that you can, if these four conditions are satisfied, have a final quiet injunction against persons unknown?
My lord, yes.
So I thought you were saying initially you can't do that.
No, you can do
You're saying
that.
you can do that.
But it will be very closely circumscribed.
Right. Now I know you're doing this at the high level of abstraction, but actually, can we just have a look, taking you right to the end of your submission?
That's fine.
At the beginning of it. But I think it's very important we keep an eye on the reality of what's going on here. And can we just have a look at the at the order that I was going
Yes.
through? We were given the colour here to see how this fits in. The dialogue does not, you say, satisfy your four requirements. So we had the coloured version, and if you turned it, it is ordered that. All right? And I went through it with him. Assaulting, molesting or threatening, those are unlawful acts, it seems to me.
Yes.
2 is may or may not be, so that wouldn't satisfy, I think, your requirements. Is that right?
Well, that's an example of the harassment.
That's an example of a
case.
harassment which isn't sufficiently precise to say exactly what is harassment. Is that the point?
My lord, yes.
So because one act isn't enough, but a whole series may be.
Exactly.
So 2 is out for whatever reason. You say 3, that must be a trespass. I thought. 6 is
You mean 5?
5. I'm so sorry. 5 is a trespass. 6 is private or public trespass. Probably private. Private nuisance. So sorry. Public or private nuisance. Banging on the windows of the store. That's obviously impermissible. Private nuisance. Painting, spraying, or fixing things to the outside of the store. That's a trespass or something similar. And then we get to 12 and 13, which, as explained, are dealing with an obstruction. Again, it's public and private nuisance. Obstructing not the business. That's not the way it's put.
No.
It's put on the basis of obstructing the access and exit to and from the premises of those people who are legitimately entitled to do so. That's the way it's put. Taking out the words in parentheses. And then 14, 15 and 16, again, it falls foul of your point about harassment. Not enough.
No, not enough
Not
by
enough there.
themselves.
But if it was restricted to the ones we've said are plainly tortious, it sounds to me, leaving aside A, we'll go back to A, but leaving aside, but it satisfies B, we don't get within C, and I think D is satisfied. Is that right?
My lord, that's right. So as long, because all of the remaining restrained acts that you've identified
Are tortious acts.
are tortious acts.
Can we now look at the description of that is your 38A?
Yes.
Can we look at 38A in the amended form? Because I think it's
Yes.
clear that it's accepted that the unamended form was
Yes.
too wide and inappropriate.
Yes.
So this one now is people who are present in the vicinity and protesting, and I think these are the critical words, and are involved in any of the acts prohibited by the terms of this order as we've now amended them. At the moment, it seems to me that you would say that's all right.
I would say that's all right, my lord, yes. And that would answer Mr. Justice Nicklin's point as well.
That would answer his points.
Because his complaint was that the redefinition of the first defendants did not work because it referred to the acts prohibited by the terms of the order, which included non-tortious acts.
Exactly.
You get rid of that,
Exactly.
and that objection is answered.
Right. So why did you say, well, that's extremely helpful, but why did you then, when you started off saying, and I may have misunderstood you, in your paragraph 20, it's on the other one, you know, 20 of the earlier submissions. Why did you say the answer to issue 5 is the grant of required temperature against persons unknown only available in the exercise of an emergency jurisdiction, which is a provisional and strictly conditional? And you said, yes, that's correct. I thought that's what you said.
I did, because it's that phraseology is directly lifted from Lord Sumption's judgment in Cameron, and he was only talking about interim injunctions.
Oh, I see. So
So it's
that
only-
is restricted
Yes.
to... Oh, right. So, but may I suggest that, that what one should do to understand it is you say, is the grant of an interlocutory quiet-timed injunction? It
Yes.
should actually, in parentheses, have that in.
Yes, it's just simply that the way that it's quoted.
Oh, I see. But you're in fact referring to an interlocutory quiet-timed injunction.
That's right.
When it says strictly conditional, what is that all about?
Simply that you would put safeguards regarding duration, ability to apply,
Oh, I see.
a rapid return
Oh, I
date
see.
into the order.
Right, right. Right. All right, well that seems to get some clarity.
Because
there.
this being a final injunction, had it been so, would have had no temporal restraint at all.
No,
So that you could have been on this pavement and you were number 13 and you would be breaking the law 50 years down the line.
that's right.
Yeah.
So all those points are relevant to the continuation of the substituted draft order as an interim injunction. But potentially different points arise if this were to be the form of order on a final injunction.
So I think that's really what we're focused on. We're focused on the question of whether there can be a final injunction against persons unknown.
Well, my lord, I queried that because I understood my Lord Master of Rolls to be asking those questions, because if this were to be remitted, if you find that there's an extant claim and it's remitted, the appellants have asked for there to be an interim injunction put in place whilst the case is remitted. And so one question is, what form should that injunction take? And from our discussion just now, my submission would be that the substituted draft order as amended by the Master of the Rolls would comply with ENEOS.
Subject to the usual
I see. So
injunction.
Yes.
what you were doing there was looking at it as an interim injunction.
Indeed.
I see. I haven't fully grasped that. I'm sorry.
Then the second question arises of the circumstances in which you could make this as a final order
Yes.
following summary judgment, and who would you have to have entered judgment against
Exactly.
in order to make this a final judgment?
Yes.
And the question is then, do you have to have named defendants or identified defendants, which is the 37 Mr. Justice Nicklin identified in his judgment, or can you, assuming you've joined that 37 and you've come to a conclusion about them on summary judgment, can you still have a final injunction against persons unknown to cover newcomers to the protest? And in my submission, on the basis of the authorities, I think you can,
Right.
but only in circumstances where the evidence that's been considered on the summary judgment application persuades the judge not of what those newcomers are going to do, because obviously that's unknowable, but that there will be newcomers to the protest.
So the court has jurisdiction to make a final injunction against persons unknown. But your condition is that only if the summary judgment test is satisfied as against some existing people. Is that right?
You would have to have, for the summary judgment to be granted at all, you would have to have evidence that the named defendants or the identified defendants had committed
Yes.
the acts complained of,
And were threatening to.
and that they were threatening to do it again. But the additional piece of evidence that would be required in my submission for a final order against persons unknown is that this is a rolling protest where persons unknown will come and join, or are highly likely to come and join.
Can I challenge you on that? Let's take the clear case of trespass, where it's certainly not uncommon, probably been quite common, where you have trespassers who can't be identified for one reason or another. And it's quite common to give both interim and final injunctions against such people, defining them as persons unknown. And I never heard it understood, I'd never not understood until now, that you could only make that injunction final if you did in fact have named people, plus you could say that there were new people coming in, those two criteria. That's not the case, I think, in the case of trespassers.
But when I say named, I don't necessarily mean Mr. Smith. I mean identified defendants that have been properly joined to the claim and served. And that may be an identified class of, I think, the type Mr. Justice Nicklin was adverting to. So it may be protester 1 holding a placard at 1402 as captured by body cam 3. So they may not be named in that sense. They may just be identified. So there are gradations of identification that you could have as defendants. And similarly, there are going to be gradations of potential subjects to a final injunction. People who will be caught to it. There will be the people who are properly named. There'll be Mr. Smith, and there'll be person X at 1402. And then the question is about the newcomers.
Well, I don't know. I wonder why you. And there is a process, I think, in the rules specifically dealing with squatters, which allows orders to be made.
So there's Rule 55.5, my lord, which is a specific process for trespass claims. And in a way, this is what we needed in this case, because in 55.5, if we just turn it up briefly, what you do is you don't just serve the injunction by placing it on stakes or notices around the site. You serve the claim form in the same way, and you post the whole lot around the site.
Yes, but you can get a final order, can't you?
You can.
And you don't have to name individuals. That's right. I mean, the rule I normally operate under is that you can, if it's in the rules, you can probably got an inherent jurisdiction anyway. Perhaps that's heresy.
I think I'm going to hesitate to make a general statement of principle in response to that, my lord. So it's actually 55.6, page 1977 of the White Book.
Yes, we're in possession of this just with claims made against the no. Claim form particularly says, which is asserted on this person's by attaching copies of it to the main door, inserting those in an envelope, stakes in place where they're clearly visible. And then you get the hearing, and you can decide the claim.
But these are existing trespassers, aren't they?
Yeah, these are people who are.
Context which I come across this is where you've got occupations of buildings and so on.
Yes.
Applications made to remove them. But they're persons unknown in the sense that we don't know their names, may not quite know even how many there are, but they're all in the building. And you can get an injunction which requires them to leave and an injunction to restrain them going back in. That's
Because they're an identified class.
And that's the
That's your
situation
point.
that
An identified class, they don't have to be named.
exactly. And again, that's just one particular form of an identified defendant, and it's the situation that Baroness Hale dealt with in the Meyer case that I handed in with the supplementary note, which is now at tab 24 in your supplementary authorities bundle.
Wanted to look at that?
Well, in brief, it deals with the question of whether you can serve a notice on adjacent land that has been already. So one parcel A has been trespassed on. Can you extend an injunction restraining possession of parcel B, which is adjacent to it, before anybody goes there? And if yes, I would like to take you to it, my lord. I think it would be
Right. Supplementary bundle, which number?
tab 24. Paragraph 38. But if I just read you the facts very quickly. So, travellers, including the defendant, established an unauthorised encampment in an area of woodland owned by the Secretary of State and managed by the Forestry Commission. Secretary of State issued proceedings alleging trespass and seeking an order for possession. So, not an injunction restraining occupation, but seeking possession of the occupied site and of a number of other unoccupied woodland sites in the vicinity. He also sought an injunction to restrain the defendants from re-entering the occupied site or entering the other sites. And when it got to the Supreme Court, Baroness Hale at paragraph 37 is answering the questions: what is the extent of the premises to which the order may relate? And I understand that to be the possession order. And then in 38, the main objection to extending the order to land some distance away from the parcel which has actually been intruded upon is one of natural justice. Before any coercive order is made, the person against whom it's made must have an opportunity of contesting it, unless there's an emergency. So that would be interim emergency stage. In the case of named defendants, such as the appellants here, this need not be an obstacle. They have the opportunity of coming to court to contest the order both in principle and in scope. The difficulty lies with persons unknown. They are brought into the action by the process of serving notice not on individuals but on the land, which I understand to be the Rule 55.6 procedure, which is, if I can put this in as an aside, analogous to but not exactly the same as the Gamel principle. It works in the same way, it's just not, Gamel principle isn't authorised by Rule 55.6. If it were to be possible to enforce the physical removal of persons unknown from land on which they had not yet trespassed when the order was made, notice would also have to be given on that land too. That might be thought an evolution too far. Whatever else a possession order may be or may have been, it's always been a remedy for present wrongful interference with the right to occupy. In paragraph 39, Baroness Hale goes on to say, whilst I would translate the modern remedy into modern terms designed to match the remedy to the rights protected, and would certainly not to put too much weight on the word recover, I would hesitate to apply it to quite separate land which has not yet been intruded upon. The more natural remedy would be an injunction against that intrusion, and I would not be unduly hesitant in granting that. So there's an example in the trespass situation.
Yes, and that's an injunction against those people who were trespassing by occupying plot A.
Yes, my lord.
Restraining them from entering onto adjoining plots. That's yes. It wasn't a persons unknown in the sense of future persons unknown.
It's not entirely clear. I mean, it says named defendants,
Yes.
but it's Meyer and others, and it's not.
Well, true. But weren't they the people who were in unlawful occupation of
They were. I think we have to assume it's
Yes.
it's the named occupants
that was
of
the
plot.
They might be
assumption.
unnamed,
Yes.
but you would define them as the persons presently in occupation of plot A.
So whilst you couldn't make a possession order in
You can't
respect
make
of
a
plot B,
possession order in respect of plot B, really the real point of principle here.
That's right, but you can make the injunction.
Yes.
And she goes on to say in the final sentence, but the main purpose of an injunction would be to support a very speedy possession order if it were broken. So as soon as that injunction were ordered, you would follow it up with the possession order immediately. So trespass is
what is the principle you get out of that? Relevant to our case?
Trespass is a special case, I think.
Well, I'm not sure it goes as far as establishing that trespass is so special a case that you can get an injunction against persons unknown who are not yet capable of identification even as a class. I don't think that establishes that proposition.
No, I think that's right, my lord.
But your point is that trespass is down one end of the spectrum and harassment is at the other.
It is, and nuisance, I suspect, tends towards the harassment end of the scale as well. And the loud hailer is probably the best example of that. Lawful protest with a loud hailer is commonplace. Prolonged siren use of a loud hailer throughout the day, drowning out everything else in the vicinity of the storm, may not be, depending on the circumstances.
I mean, I think that trespass is I agree, I mean, it is clearly one end of the spectrum. Principally, I think, because it's much easier to make the human rights balance in the case of trespass. I mean, the answer isn't automatic. I mean, we remember the the US nuclear base, Greenham Common. The Ministry of Defence didn't get an order for possession there, despite the trespass on the land. But in most cases, of the sort of case we're talking about, it's highly unlikely that the human rights balance will favour permitting the trespass. So in that sense, it's an easier
It
area.
is. And I think the additional problem with the nuisance and harassment end of the scale arises out of the Burris example.
Yes.
Because in Burris, the exclusion zone was granted because I think the phrase used was that Mr. Adesanya would be tempted into doing bad things were he to cross into it on the evidence of his previous behaviour. So you have to show a threat of escalation of action once you're within an exclusion zone. And Burris might be regarded as a special case from that point of view. But because nuisance and harassment proceed by escalation and by increment, I hesitate to say you would never be able to make a final quia temit injunction against persons unknown that restrained non-tortious acts, because it's conceivable that there could be circumstances where to catch nuisance and harassment by repetition, you would be able to show that there was a threat of escalation or a threat of temptation. I mean, it's quite hard to see how you could do it in these circumstances. But at the level of high principle, I would hesitate to rule it out completely.
I think what you're saying probably is that I mean, just the principle would apply even if you've got a named defendant, which is the point about the Burris case.
Yes.
That it may be necessary to enjoin acts which are taken by themselves unlawful because the likelihood is that they're going to be part of a process.
Yes.
But that doesn't really help on the question of whether the injunctions can be granted against persons unknown. I mean, what I have in mind in saying that is, how is that Cameron point to be dealt with? How is the decision of the Supreme Court in Cameron to be dealt with in the case of future persons unknown? In fact, more than that. That's for me the issue which I'm concerned about.
Yes, and I think the answer is that they are only bound by the terms of the injunction. So the newcomers who are going to be caught by the final injunction against persons unknown, they've not been party to any of the proceedings. They will just be caught by the injunction by breach, and it will be served in the normal way. And they'll have liberty to apply or to vary.
But the order has been made against when applying Cameron, they've never been subject to the jurisdiction of the court because they haven't been served.
So can
That's
you,
the argument.
basically, can you have a remedy against a non-party to a summary judgment?
Or even after a trial. So
Yes.
that's a non-party who's not been served in any sense.
Well, who may have been served, because that category may be overlapping. Because,
Well, I mean, we're not
But it's
talking about the 300. We are talking about genuine newcomers, people who've never been
Yes.
there, never done anything that the claimants know about to indicate that they are prospective
yes,
demonstrators. What I don't really quite understand is how Cameron is applied to permit a final order against future persons unknown, if I can call them that.
I'm trying to think of other examples in which you grant a remedy against
Well, the only
non-parties.
one I can think of actually is the only one I've been able to think of are the press restrictions contra mundum. I mean, so particularly, for example, in the Venables and Thompson case. But that's a very special case. I mean, I can't think of any other, well, I personally can't think of any other examples of permanent orders made against future persons unknown.
We should probably look at Vastint, my lord, as the case of Vastint.
Well, Vastint, I agree, but that's a first instance.
It is
decision,
first instance,
and
yes.
It predates Cameron,
It does.
and it doesn't address at all the issues raised in Cameron.
And it was distinguished by Mr. Justice Nicklin on the basis
Well,
that...
I mean, there it is.
There we are,
It's,
yeah.
I mean, the Cameron points just weren't raised at all as I read Vastint, which, as I say, it's not surprising since Cameron hadn't yet been in the Supreme Court.
The alternative to there being a final injunction against persons unknown being that the appellants to restrain newcomers, that particular class, would have to make a fresh application for an interim injunction.
That's the problem you get into, because once you accept you can have an interim injunction, what are you to do? But you can't have a final injunction. I mean, what are you to do? Are you to limit it, and then there's an application with a fresh interim injunction? So you just get a whole series of interim
Yes.
injunctions. That doesn't seem to be very practical. That therefore suggests that there must be, if you can have an interim injunction, that does seem to suggest that you must be able to, intuitively, that there must be something you can frame by way of a permanent injunction, subject to whatever the constraints are.
And thinking about...
I mean, that's my issue. I mean, there definitely is. There's no question there is power to do this on an interim basis, and I don't think any of the cases say yes, but it's necessarily limited. So I mean, there are two possibilities. One is you have an interim injunction and it can be renewed all the time, forever.
Yes.
That doesn't seem to be right. Or alternatively, it's time limited, and by the time it finishes, you've got to have some actual people, but it's limited to those actual people. But then you would have thought, well, then that means you can have an interim injunction for the other people. So I mean, that's the way you carve it up. As you say, you've got some, at the end of your interim injunction, you get the final injunction. You say, well, you've got actual individuals who can be identified, if not by name or by location, in some other way.
Yes.
And then you say, well, you can also deal with this other category, people in the future. But if you can't have a final injunction against persons unknown, you can't deal with that category.
No, that's right.
Which means you're left in and it can't be right that the court would say, yes, you can't deal with them at all. If by the end of 2 years you don't know everybody, you can't have any remedy at all. That doesn't make sense.
And I suppose once, 2 points occur to me from that, my lord. The first is that it can't be a question of evidence, because if you can muster the evidence to demonstrate that an interim quia timit injunction is required, you can use comparable evidence to justify a final quia timit against persons unknown, and you'll have the added advantage of findings of fact in the summary judgment or trial against the identified defendants, and potentially against the 400 or whoever many were there en masse. You'll have maybe descriptive findings in relation to them, even if you don't have findings that they were committing tortious acts. So you will have the evidence base on which to make it. And the second point is, I suppose, if you are making a remedy against a non-party, how are their rights to be protected? The first point is that the court will have to carry out a Section 12 proportionality balancing exercise in determining the terms of the injunction. The second point is that it can be limited in time, as my lord suggests. The third is that you may
They can
have...
apply, presumably, to discharge.
Exactly, you'll have liberty to apply to discharge or vary.
If they know about the proceedings.
No, but this is...
But
what
they
it
will
says.
know.
It's in the order.
I mean,
so-
And the order will be plastered all round the Canada Goose premises.
Well, it could be posted on social media and so on, couldn't it? I mean, giving notice in a general way would be perfectly possible
Indeed.
by those sort of people. So, as you say, posting the ground.
But the easiest way is to, because the
Well, they can, well, if the worst comes to the worst, I mean, you enforce this thing by way of a contempt application, that usually, so
That's
something's got to be served on them at some point, and at that point at the latest they can say, well, yes, but I should never have been joined to these proceedings, I don't fall within it, or it's too wide. It's open to them to do whatever they want.
Indeed, my lord.
Well,
I mean,
it's a curious point that, isn't it? Because, I mean, strictly speaking, and this comes out of the authorities, what they should do is apply to the court to vary the order before they breach it.
strictly speaking,
Because breach of an order is breach of an order, even if it shouldn't have been made.
and in my submission, the additional safeguard that meets the Cameron point to some extent, my lord,
Yes.
is that you would give notice of the injunction not merely to the relevant social media sites, but you would do it physically at the location of
Yeah,
the
I follow.
protest, and that's important where you have defined the protesters in terms of the location as here. So then they have notice of the injunction and its terms, as my lord says correctly. Properly speaking, they should then apply to vary or discharge before breaching
That's been
it.
said in this court.
But what we suspect will happen is that they'll breach it,
Yes.
and they may get away with it, or someone will bring an action for contempt,
Right.
and they'll have notice in a secondary way by that means as well. It's hard to argue that a protester does not have notice of the injunction if it's
Well, this is
put on
raising-
lampposts.
This
in
was,
the
all
area.
these points are raising quadruple, but of course it was an interim. But in Cameron, Lord Sumption acknowledges the jurisdiction of the court to grant persons unknown
Yes.
injunctions in these sort of circumstances as a temporary emergency measure. But he's not, I mean, what I am concerned about is whether, I mean, as I read it, what he says there doesn't suggest that, you might say doesn't address, but I don't think approves the notion that you can have a permanent order without service of some form.
My lord, I just don't think he addresses the point at all.
Well,
He doesn't get as...
I'm not sure, because he's really saying that subject to one or two of these exceptions, service is necessary in order to ground the jurisdiction of the court.
He says that in relation to...
Can we actually look at the case?
Yes, I'm just... it's tab 17 in the authorities bundle, and paragraph 17, I think, is
So it's paragraph 17.
the relevant point, because he distinguishes between the protection that you get and the way in which you become subject to the jurisdiction by service of the claim form, and the alternative way in which you become subject to the jurisdiction of the court by getting notice of an injunction. So it's a different type of jurisdiction.
Sorry, let me just read something.
so paragraph you want us to read?
It's third sentence, my lord. It's literally, it is a fundamental principle in the third line
Yeah.
that a person cannot be made subject to the jurisdiction of the court without having such notice of the proceedings as will enable him to be heard. And of course, there are just different types of proceedings. Interim injunction is one type of proceeding. Proceedings that are then issued via a claim form to lead to summary judgment or trial of a cause of action are a second type of proceeding. And arguably a third type of proceeding is the remedy that flows after the determination of that cause of action, and whether it's sufficient for notice of the remedy to be given to that non-party. But I don't think Lord Sumption addresses that final point, but that is the point that my Lord puts to me.
When he says without having such notice of the proceedings as will enable him to be heard, I'm bound to say I had taken that to mean notice of the underlying proceedings, so he could go to court and say, I'm a defendant and I object to this because. Isn't that what he's got in mind?
If that's
If you have a notice of an injunction, it's completely different. It's an order that's already been made in existing proceedings of which, on this hypothesis, the defendant was unaware.
And if that's right, my Lord, then the procedural answer, I suppose, is to serve the claim form and the interim injunction at the outset, by analogy with the trespass case, so that on all the lampposts around Canada Goose, you don't simply put the notice of the injunction, the interim injunction, you put the claim form as well and the particulars of claim, because then persons unknown and newcomers have notice of the proceedings. And if you'd done that at the outset, arguably, you could then have your final injunction against newcomers, because that requirement in 17, notice of the proceedings, or my Lord Coulson's definition, is met.
As will enable them to be heard. You see something on a wall at Canada Goose. It's the claim form as well as the injunction, and you're the 13th person, so you're in breach of the injunction and you're liable for committal proceedings. You've never had any opportunity to be heard.
But that may be a function of the way that the exclusion zone is set up, and the 13th person arriving rather than
It goes back,
the form of
we have to
notice.
take the case of the newcomer who arrives after the final order has been issued. I understand the way you're putting it in respect of people who have arrived before the final order. But if they arrive after the final order, then in no sense have the proceedings been served on them before the order has been made against them.
No, that's right, my Lord, they haven't.
And isn't that the point that Lord Sumption is grappling with in Cameron? As to whether that's permissible, whether it's within the jurisdiction of the court to make a final order in such circumstances.
The trouble is that
He doesn't.
paragraph 13, that he sets out his two categories. He's not looking at this type of case at all. He's looking at cases where something has already happened. So the first category is anonymous defendants who are identifiable, whose names are not known. Squatters occupying a property. So this is something, these are people who are there. They're identified by their location, although they cannot be named. And then the second category comprises defendants such as hit and run drivers, who are not only anonymous but cannot even be identified. He's not really focusing at all, is he, on a kind of fluctuating group over time.
My Lord, I think that's right.
He's not addressing that at all.
And I think that third sentence in paragraph 17 is the closest that you get to a statement of principle that might cover that case. But in my submission, it's not at all clear that it's intended to do so.
Which is it is a fundamental principle of justice.
It's a fundamental principle of justice.
As I said, the trouble is, and maybe there's no answer to this, but I mean, the trouble is, there is a jurisdiction to grant interim relief against persons unknown, which is a fluctuating group. There is such a jurisdiction at this level. I mean, it may not be the Supreme Court, but at the level of the Court of Appeal, there is such a jurisdiction. And therefore you're faced with a dilemma. It's quite a straightforward one. We either have to keep the interim injunctions going forever, maybe that's right, but it seems a bit ridiculous,
Yes.
or you must fashion somehow or other something which will give justice. And your suggestion is, well, that can be achieved by making sure that, that not only do you have an alternative service by putting things on, maybe on social media, maybe requirements to it, maybe all sorts of ways of doing that, including putting up notice everywhere around the premises. But, as I understand what you're saying, is you should make sure that when there are people who you say are breaching the order, you serve on them a copy of the relevant things, the injunction and the statement of the particulars of claim, I assume, the writ, the particulars of claim and the injunction. At that point, although it's belatedly, they can then do whatever they want.
Which would and whatever they want might include, I imagine, applying to the court to discharge a particular term of the injunction on the basis that it's drawn too widely.
They can't do that if it's a final order. Because
Well,
it's finished.
it's fair to say that, I mean, it probably could be in this case, the claimant is seeking to include in its final order a power to apply to vary or discharge.
Indeed.
And also an order made in the absence of one of the parties.
I think there is that too. isn't there? Yes.
An absence in if that person becomes a party to it, or I guess they are a party.
They are a party. They can't be added. They already are.
But if it's decided in the absence of the party, you can apply to do all sorts of things. I don't think that's a huge problem. The problem is that Lord Sumption doesn't seem to be dealing with this case at all, and therefore isn't faced with this dilemma. I mean, they may say in the Supreme Court, well, you can't even grant quiet injection, interlocutory injunctions. But we don't have that luxury.
No, and I think I agree, my lord. I don't think the point is addressed squarely in Cameron in a way that allows you to say, yes, you can, or no, you can't.
Well, I mean, I think he does accept, because he refers to some of these cases, doesn't he? He refers to, there's the Bloomsbury Publishing case he refers to.
And he refers to Ineos. It's at paragraph 11.
He does refer to it at first instance, yes. And Hampshire Waste. Well, that's that was a person's unknown case, I think, but it was very temporary.
Yes. I had wondered whether those were the cases in paragraph 11 which he had in mind at the start of 17 when he said, this is in my view a more serious problem than the courts in their more recent decisions have recognised, and then makes his point about justice being available to both sides and it being a fundamental principle that you have to have notice.
And I think perhaps the way to determine that is to go away, and I confess I haven't done this exercise, is to identify whether those cases in paragraph 11 are in fact final or interim injunction cases.
Yes.
We know that Ineos is interim.
Yes.
Um,
Doesn't he somewhere talk about temporary and urgent injunctions?
yes, and that's paragraph 14, my lord, on page 1480. And that's the emergency jurisdiction, which is provisional and strictly conditional quotation that we started with.
Where is that?
It's at 1480 B to C in paragraph 14.
So that's before the proceedings have been served, or even which the court may grant interim before proceedings have been. That's an emergency jurisdiction to a provisional conditional.
And the provisional and conditional is envisaging, obviously, the normal procedure for a return date, a speedy return date, permission to apply, to vary or discharge. And in most cases, I would submit probably a more tightly drawn order than we have here.
I mean, he's obviously got, yes. I mean, I think it probably would include the persons unknown cases that he refers to, but it obviously goes wider.
My lord, yes.
I mean, he doesn't actually say all those cases are wrongly decided, does he? No. I'm not quite sure what
No, I mean that, yeah, sorry. See, I suppose the problem that, it is that sentence in paragraph 7,
Yes.
which is the real issue here, I think. Now, and he sees that sort of interim injunctions and so on are an exception to that.
Well, I suppose you could say that providing you give a wide enough notice of the issue of the proceeding, or wide enough issue of the issue of the proceedings, it notifies everybody who might see it whether they have yet demonstrated or not. I mean, you could say, as long as there is sufficient notice given, you could say, well, such a person, I suppose, could come along and object. If the person is interested, I don't know.
I think it's certainly arguable, my lord, that you can give notice of everything that has happened before and all the provisions that you're now subject to in a final injunction.
It's like a type of, in a sense, we have to look at, perhaps you might look at those over, the council might look at those overnight, these injunctions which are granted in restraining publication, generally, which affect every sort of super injunctions, you know, which operate against everybody. There's no service on everybody, but they're all affected. But they can apply. What happens is they know about it, and they can apply. They apply to discharge it, or they object to it. Anyway, I think we probably have to stop there.
My lord, in addition to the super injunction point, are there any other specific areas we can assist the court with overnight? Or I in particular can assist you with?
Well, I mean, by super injunctions, my lord sort of means or includes the sort of contra mundum
Yes.
type
That's
cases.
what I'm really talking about.
Yeah.
Yes.
That's, I mean, I have had a look at the Venables case, which is a first instance decision.
But anyway,
from the family division.
it must be the position that in the quadrilla case, the Court of Appeal took the view that certainly you could have interim relief against persons unknown, notwithstanding that the persons unknown have not been served.
Yeah, I don't think there's any question of that, and that actually was, in a sense, decided in Ineos, because it was argued in Ineos that there could be no, that you couldn't have an interim injunction against persons unknown.
Ineos is before or after?
Before.
Yeah.
So that's that is certainly established at the level of this court, that you can have an interim injunction against future,
Yes.
the real part, future persons unknown.
But then that, in a sense, that is, am I wrong in this, but that seems to me then to show that there must be some qualification of the statement of Lord Sumption in 17. A person cannot be made subject to the jurisdiction of the court without having noted the proceedings that will enable him to be heard, because these people, on the nature of it, haven't been heard, but they're subject to the interim injunction.
Yes. Yes, my lord.
It can't be. If that's right, we have to read that as qualified in some way, don't we?
And he does qualify, but by reference, because of course, as he himself says, we know that the court has jurisdiction to grant an interim injunction before proceedings are issued, let alone served. So that much is accepted.
Yes.
The question is, do you deduce from the jurisdiction to grant an interim injunction
Yes.
But there is jurisdiction to grant a final injunction. Is one way of putting it.
It's one way of putting it, but there are entirely different procedural issues at play in
Yes.
both, in that the normal course of proceedings from interim to injunction to trial builds in safeguards that
Yes.
give
Yes.
notice. So you've got a return date, so you get as close to notice as you can,
Yes.
and you can come back immediately and
Yes.
apply
All that.
all that.
But I mean, underlying it is the question: is it the function of civil litigation to legislate for the future, not just for the parties to the litigation, but for the whole world? Or is that not properly? That's more a matter for statutory regulation.
Or, my lord, if it can be done subject to certain stringent procedural safeguards, which we've already
Well,
discussed.
you have to have those,
Yes.
whatever.
It can,
Whether
or
it
to
was
say
a
it can
statutory
only be done.
jurisdiction or a common law jurisdiction or whatever. Yes.
We'll leave it then. 10:30.